unmuting. Not that bad. It doesn't have speed in it, that's why. Ooh.
Yeah. Did you want to try?
Poker face.
36.
Yeah, right. That's pretty.
7.
I thought you were just gonna be like, it's mine now.
I did too. Oh my gosh.
Be off the same time.
Order with.
You
Oh,
stop
you enjoyed it now.
and this.
Okay.
I mean, I like it in here, but because there's so many, it's mine.
Here we go. Obvious memo. Okay, folks, where that went. We're back in order. We're now in open session. And we're proceeding. We're now on agenda item 48 of the meeting agenda, the regular meeting agenda. And the topic is lobbyist client penalty correspondence, and Executive Director, agenda item 48, please.
Yes, this is the Oregon Employment Department as a lobbyist client. They've had prior violations. The third violation, penalty of $150. My rec reduce it to $30, which is a 20% reduction.
Any comments? And seeing none, Vice Chair Friscom.
Quick question, the rationale for the reduction is, in your judgment?
Our practice has been, you know, if it's a first violation, they get a letter of education. A second violation, we do sort of 10% or $20, whatever's greater.
Right.
Third violation, 20%. And so that's where it fell this time.
That's how you get
20%.
That's how you get to 30.
Yes.
If you do that math, which I'm not doing, right?
Yes.
Okay, thank you.
Okay, you have a motion?
Here I do. I will hereby move approval of the staff recommendation relative to item number 48, dealing with the lobbyist client penalty correspondence for the Oregon Employment Department, a penalty of $30 for Q1 2024.
All right, commissioners, any comments? Seeing none, we'll call for the vote.
Commissioner Mason,
Aye.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Ms. Myers, 49, please.
Salem Chamber of Commerce, again, third violation. They had a penalty of $300 at 20%. My recommendation would be 60.
Thank you. Vice Chair Fiscom.
Mr. Chair, I will move approval of the staff recommendation to impose a penalty of $60 on Salem Chamber of Commerce.
Commissioners, any comments? Seeing none, we'll call for the vote.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Myers, 50.
Yes, Richard Cutler, he is I believe, a planning commissioner for Lincoln County. He has had multiple violations before and either got reductions or letters of education. He has 2 pending violations for his 23 and 24 SEIs. I am recommending reduction of the $240 to $75, and this is a 30% penalty given the number of violations he's had. But as his explanation notes, he is 91 years old and living on a fixed income. So that is a consideration in my recommendation.
Thank you. Vice Chair Fiscom.
Mr. Chair, I will move that we approve the staff recommendation, SEI penalty correspondence involving Mr. Richard Cutler to reduce the penalty to $75.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Chair Lindsay.
Aye.
Motion passed 7-0.
51.
Judge Kippinger, she had 1 prior violation. She paid in her 24 SEI. She incurred $160 in penalties. I am recommending reducing that to $20, which would be 10% for the second violation.
Thank you. Vice Chair Fiscum.
Mr. Chair, I recommend approval of the staff recommendation involving Ms. Denise Keppinger, reducing the penalty to $20 for 2024.
Seeing no comments, we'll call for the vote.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley. Aye. Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Right.
TJ Johnson is a school board member. He has 2 penalties. One is for his 2023 SEI, which he reached the maximum of $5,000. And on his 2024, he incurred up to $760. My recommendation is a letter of education. He has now filed both. A letter of education for 2023, which is what we've done for others, and reducing his 24 penalties to $75, which is 10%.
Thank you.
Mr. Chair, I hereby move the staff recommendation, a letter of education for 2023 and penalty reduction to 75 for 2024 for Mr. TJ Johnson.
Seeing no comments, we'll call for the vote.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley. Aye. Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
And 53.
Ross Ketcher, he had a prior violation, got a letter of education. His current violation was $160. Recommend a $20 penalty, which is 10%.
Vice Chair
Mr.
Fiscum.
Chair, I move approval of a letter of education and a penalty reduction to $20 for 2024 to Mr. Ross Ketcher.
Thank you. Seeing no comments, we'll call for the vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley. Aye. Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Thank you. Okay, we're now on the stipulated final orders. I do want to comment that I believe at our last meeting, we had discussed whether we could move the stipulated final orders to the consent calendar. And based on counsel that we received from our legal counsel, it was recommended that we not put it on the consent calendar, but that we vote on them individually. However, we do not have to have a full report on each of them. But we'll have Executive Director Myers will report on agenda items 54 through 58 in this instance, and then we can vote on them individually.
Thank you, Chair Lindsay, Commissioners. It's actually 54, 55, 56, 58, but 57 is not
Oh.
the latest.
Thank you.
Okay, Morrow counties. These cases began in 2022. Someone filed a written complaint. They were opened to determine whether 4 members of owners of a company called Windwave, which is a fiber optic company in Boardman or Morrow County, had used their positions on the Port of Morrow and the Board of Commissioners to advance the interests of their private business. And the reason is that the Port of Morrow and Morrow County were in the Columbia River Enterprise Zone called CREZ, and CREZ was negotiating with Amazon to provide them, you could open your data centers here, you will get these tax breaks. Amazon in turn has awarded contracts to Windwave, the company owned by these gentlemen, to install fiber optic cabling or conduit to the facilities that Amazon was building. And so the question before us was, did these gentlemen in their official capacities on the Board of Commissioners and the Port Commission have conflicts of interest or engage in a prohibited use of office. Now, please keep in mind, there in the newspaper reports, there have been sort of questions raised about their purchase of Windwave and whether that was a violation. That is not before the commission, nor could it be, because it occurred more than 4 years prior to the date of the complaint. So while that may be of interest to DOJ or other groups, it is not the question before the commission. What we were looking at is when these gentlemen were in executive session, usually for the Port Commission or the Board of County Commissioners, and they were voting on, should we approve these agreements with Amazon? Did they make the appropriate disclosures of conflicts of interest? Now, realistically, they would be at most potential conflicts because awarding the contract to Amazon does not guarantee with certainty that they will receive a financial benefit. However, we do note that in the 4 years of this inquiry, Windwave, the company they own, was awarded 20 different contracts from Amazon to install fiber optic cabling to the facilities in Morrow County. So what happened in these past 2 years with the case was I got to listen to and re-listen to well over 100 different meetings of the Port Commission and the Board of County Commissioners. And they are all represented, and there was extensive negotiations with opposing counsel. Those negotiations, it was not, are they benefiting Amazon? Amazon is not before us. We have no jurisdiction over Amazon. It also was not, are they awarding contracts to Windwave? Because that wasn't the question before us, and there was no information of that. It was when they're considering anything to do with Amazon negotiations, what was being discussed, and could what was being discussed potentially result in a financial benefit to their business? And if so, did they make the appropriate disclosures? In reviewing those hundreds of meetings and then negotiating, going back and reviewing them again, we basically whittled it down to those meetings identified in the reports that are in your meeting, in the snips in your meeting books, which is, yes, there may have been 67 different meetings where the Port Commission in executive session discussions mentioned the word Amazon. But in re-listening to those meetings, that discussion was not one that could result in a financial. It was, a very brief mention or mention of something that would not have any financial impact. So we basically narrowed it to those meetings where they were either discussing awarding contracts to Amazon that could have a financial impact on Windwave, or related matters. For example, the Board of County Commissioners there was a couple meetings where Mr. Russell was discussing Windwave needing permits, easement permits on a road construction for the work that Windwave was going to be doing for Amazon. So there are stipulated orders that are in your meeting books, provide that these respondents will each pay $2,000 in civil penalties. And again, this is a resolution only of the questions before us, which is, did they have conflicts of interest or use of office relating to the meetings where they discuss Amazon?
Thank you. Any questions? Mr. Fiscom?
I'll yield to colleagues if anybody has any questions, and with your indulgence, Mr. Chair, I think I have several, but I didn't count them, so I'll be quick as I can. Executive Director, thanks for your report. I appreciate reading it and I appreciate the thoroughness of what you've done. A couple of questions. Can you summarize for us how you arrived at the level of penalties imposed in these documents?
Yes,
$2,000.
yes, as the commission knows, we operate in negotiating penalties from a penalty matrix that is in the administrative rules. And so we applied the number of violations, the number of times. With some of them, it was 6, with some of them, it was 9. The financial benefit, we basically used the maximum because the value of the contracts that their company had gotten far exceeded what is in the matrix. How long it had occurred, etc. And based on the results, it recommended the penalty of 20 to 40% of the maximum allowed, which in this case, maximum would be $10,000. And so the penalty recommended was 20% of that.
And Mr. Chair, may I continue? Thank you. I presume that what happened was there was properly some negotiation with the parties over the STIP as well as, but especially the amount.
The negotiation, actually, there was extensive negotiation. It was less about the amount and more about was this particular meeting a violation versus another meeting.
Fair enough.
And so that is where it ended up.
Thank you. Third question quickly, did the value or revenues that could be associated with WindWave have any basis in the negotiations with these individuals on your part?
Other than in the penalty matrix, the amount of money that WindWave would have received was a calculation, and it was the maximum allowed by the penalty matrix.
Thank you. And you answered one of my, excuse me,
Go ahead.
you answered one of my questions, so I'll just say thank you for the answer about was Amazon investigated in this, and we have no authority to conduct such an investigation. One last question, I think it's the last one. I noted in several of these documents, several of these that are facing in the next moments, there was something I don't know that I'd seen on a routine basis in STIFs, which is a reservation of rights. Can you explain that context for us?
My understanding is that these gentlemen may be facing other investigations or litigation down the road from other parties. They are agreeing to settle the cases before you through this STIP, but they simply want to reserve their rights should they have other cases to argue their cases and not have our resolution of these facts set precedent in every other case that they might be facing.
And I did have one final question. I apologize, which is, I understand that there's some kind of a Department of Justice investigation of some of these, if not all these individuals. How would you characterize that? And is there any sense in which we should not proceed pending results of that DOJ investigation being known to us?
My understanding is that there is an ongoing DOJ investigation, that it is not a criminal investigation. We have no need to suspend for criminal. My understanding is that the DOJ investigation concerns those matters that predate the period of our investigation, of our jurisdiction, and not so much what we examined in the course of our investigation.
Okay,
Thank you for your patience, Mr. Chair.
Commissioner Mason.
Thank you, Chair. So you answered a few of my questions, but if there's a current investigation, I feel uneasy about voting to support a negotiated amount when there's still an investigative process. I guess I know that's different than what we are, but I guess taking a reduced penalty and having the commission sign off on it seems inappropriate based on what we just learned. Am I the only commissioner that feels like that? So that seems, if the max penalty is 10 grand, we're negotiating a $2,000 penalty, stipulated agreement. That just seems slightly inappropriate.
If I could clarify, as I explained, there were two issues when the case originally came. One was, did they act inappropriately or in violation of some law when they bought WinWave, which had previously been owned by these nonprofit intergovernmental entity that they had created. That is what's being examined because that isn't in our jurisdiction. It's past our 4 years. So what DOJ, what they ultimately determine in that would have no bearing on the case before the commission. It's outside of our jurisdictional period. The only things that would relate to the case in our commission is, what did they do in these meetings? So while it's understandable that people see the two matters as related, they really are two very separate cases that the determination of one has no impact on the determination of the other.
Yeah, and I would also say that this takes both sides to agree to the stipulated order, meaning besides these terms, they might not agree to it. So, all right, Vice Chair Fiscom.
One last question. Thanks for your patience. Building on Mr. Mason's comment. There is no way for us, I think I know the answer. There is no way for us as a commission to go on pause. We either have to proceed to accept this or reject it. If we reject it, the negotiation starts again anew, does it not?
Or I would present an investigative report saying I recommend these findings and they would have a right for a contested case here.
But for the record, there is no pause ability.
No.
That we don't have that authority. I think I know that answer. Thank you.
All right, commissioners, any last questions? Seeing none, Vice Chair Fiscom, do you have a motion?
I will yield to a colleague who has one. Well, I'm happy to make one. If you
Go ahead.
Rather. Thank you. I'll put my glasses on so I can read it.
And by the way, commissioners, we're going to do 54 through
55, you say 58.
58 is actually separate because it was an SEI filing case.
Right. Yeah, I understand that. We'll skip 57 when you do these, but then we're going to go right back into going through all of them without comment.
That's fine. Thank you.
So through 72. So get your water ready.
Thank you, Brenda. Item number 54, Mr. Chair. I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Any comments on the motion? Seeing none, we'll call for the vote.
Commissioner Mason,
Nay.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
No.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-2.
5.
Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such with regard to item 55 on our agenda.
We'll go ahead and vote.
Commissioner Mason,
Nay.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
No.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-2.
Mr. Chair, with regard to item 56, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
We'll go ahead and vote.
Commissioner Mason,
Nay.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscom,
No.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 5-2.
58.
That may be a separate one, Mr.
Yeah.
Chair.
If I could, excuse me, 58 was not related to the investigation. It was a complaint saying that Mr. Padberg had not included info on his SEI. He amended his SEI, and this is simply a step for a letter of education.
Sure. So let's just go 57. We'll go all the way through 72.
Whatever your pleasure is.
57, please.
57, Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter and that the chairperson be authorized to sign it as such.
We'll call for the vote.
Commissioner McCauley. Aye. Commissioner Burke. He's muted.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Nay.
Chair Lindsay.
Aye.
Motion passed 6-1.
58.
Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, item 58, and that the chairperson be authorized to sign it as such.
We'll vote.
Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Nay.
Commissioner McCauley. Aye. Chair Lindsay.
Aye.
Motion passed 6-1.
59.
Item 59, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, item 59, and that the chairperson be authorized to sign it as such.
We'll call for the vote.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Nay.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Chair Lindsay.
Aye.
Motion passed 6-1.
60.
Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, item number 60, and that the chairperson be authorized to sign it as such.
We'll call for the vote.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, item number 61, and that the chairperson be authorized to sign it as such.
Call for the vote.
Commissioner Payne.
Aye.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
2.
Mr. Chair, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, item number 62, and that the chairperson be authorized to sign it as such.
We'll call for the vote.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item number 63, with your indulgence, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item number 64, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Call for the vote.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Commissioner Burke.
Aye.
Commissioner Newell.
Aye.
Commissioner Fiscum.
Aye.
Commissioner Payne.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
4.
Mr. 65, man.
65.
Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, item number 65, and that the chairperson be authorized to sign it as such.
Vote.
Commissioner McCauley. Aye. Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item 66, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
Vote.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item 67, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
And call for the vote.
Commissioner Newell,
Aye.
Hi, this is Bob. Oh, I'm sorry.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Item 68, Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and the chairperson be authorized to sign it as such.
Vote.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
On item 69, Mr. Chair, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
And vote.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item 70, I hereby move that the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
And vote.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item 71, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
And vote, please.
Commissioner Mason,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Mr. Chair, item number 72, I hereby move the commission approve the proposed stipulated final order as the final order in this matter, and that the chairperson be authorized to sign it as such.
And vote.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
Okay, thank you. All right, let's now move to agenda item 73. It looks like we have two reports on investigations. And Investigator McIntyre, right? No.
No.
Oh, okay, I saw the EHM. That's old. Okay,
It was Hillary's case.
yes, go ahead.
Thank you, Chair Lindsay, Commissioners. For the record, this is Casey Fenstermaker. Item number 73 in your meeting books is an investigative report for Karen Cheery, a former administrative supervisor with the Portland Police Department. This investigation follows an own motion by this commission based on an indictment and media reports regarding that indictment. Cheery's husband was criminally charged following an altercation with and the death of an individual in Portland in 2021. Shiri herself was charged with multiple crimes related to her husband's prosecution, including tampering with physical evidence, official misconduct, and multiple counts of hindering prosecution. Shiri was alleged to have visited the precinct where her husband was being held, requesting to see a detective supervisor and accessing floors of the precinct not generally open to the public. The commission moved this case to investigation to review for possible conflicts of interest or prohibited uses of office. The commission subsequently suspended the investigation until the criminal charges were resolved. Criminal trial was held in March of this year. While the majority of the charges against Shiri were dismissed prior to or during that trial, the judge waited to issue a verdict, a not guilty, on the official misconduct charge until the end of the trial. Following the judge's announcement of that not guilty verdict, he explained the rationale for his decision and made it abundantly clear that there was no evidence to support that Shiri had acted in her official capacity to either interfere in her or her husband's prosecution or to obtain access to the precinct. The report in your meeting books recommends dismissing the complaint against Karen Shiri.
Thank you. Commissioners, any questions? Seeing none, we'll take a motion.
Mr. Chair, I hereby move that the commission find that the information before the commission is insufficient to infer a violation of ORS
240,
Yeah.
244040 and 244120.
two citations in ORS 244, and that this complaint be dismissed. Is that adequate, Executive? Thank you.
Commissioners, any questions on the motion? Commissioner Payne.
I just want to ask and make sure, because there are different burdens of proof in the two proceedings, that there's a burden of proof beyond a reasonable doubt in a criminal proceeding, and then ours is just substantial evidence, I believe, that we did our own investigation based on that different burden of proof. And I'm fine if there's no evidence, but I just wanted to understand whether we considered those different burdens of proof, and just because this person was acquitted under a higher burden of proof, that wasn't the only reason that we are recommending dismissal. So I just wanted to ask that question of staff before. I'm fine with dismissing. I just wanted to understand whether that was considered before recommending dismissal.
Yes, thank you for the question. It in fact was considered. What we had here was a situation where the allegations were based purely on the newspaper articles about the indictment and the indictment itself. We had no independent allegations that this individual had in any way used her office to benefit herself or her husband. And so it really was based on the alleged criminal charges. So we didn't investigate it.
I would add that in the transcript of the hearing, the judge made it abundantly clear that when she was visiting that precinct, it wasn't like she was using her badge to try to gain access to anything. She was simply doing what any member of the public could do, which is, I want to go talk to this detective. And she was the one that got directed to go upstairs and wait for him or find him. It wasn't so much her moving in to try to do something in her official capacity.
Commissioner Payne, are you still there?
Yes, thank you.
Okay. Commissioner Newell.
Thank you. I just, in an abundance of caution, as they might say, I am a prosecutor in this office, but I have no knowledge of this case. I had no interaction with this case, and I'm comfortable voting on it today. Just wanted to put that out on the record.
Thank you. I also want to note that Ms. Shiri and Mr. Parker, her attorney, are online. We didn't really give you an opportunity to say anything. You're welcome to say something now if you'd like. At the same time, you'll see where it looks like where this is going. Do you want to have any comments or not? Ms. Cheery or Mr. Parker?
With not saying anything, thank you.
Okay, thank you. All right. All right. Sorry, did you already make the motion?
Yes,
Yes,
we
okay.
already voted. Sorry about that, Mr. Chair. It's a long day and already,
Yeah. Did we?
And the
Did
one.
we vote?
We haven't voted.
haven't voted? You need to have two new officers up here. Mr. Chair.
These guys are having a fun time over here. All right.
What'd you do on
We
that?
will call for the vote now. Thank you.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Newell,
Hi.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Hi.
Commissioner Mason,
Aye.
Chair Lindsay,
Hi.
motion passed 7-0.
All right, Ms. Cherry and Mr. Parker, that resolves that, and we thank you for being with us today, and our staff will follow up. Thank you.
Thank you.
All right, the next item on our agenda is agenda item 74 with respondent Chuck Schultz. And he is attending today. And Michelle Eldridge is, I can't remember what that role is.
She is the city administrator.
Okay, hello, nice to meet you. Okay, with that said, we will go ahead and Investigator Pacheco will give his report. Thank you.
Thank you, Chair Lindsay and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 74 in your meeting book is an investigation report for Chuck Scholes, Public Works Director for the City of Harrisburg. The complaint alleges that Mr. Scholes has been living on city property for the past several years. After the complaint was brought to the attention of the City Council on May 9, 2023, the council agreed to let Mr. Scholes reside on city property for only $1 a month. However, on December 29, 2023, the current city administrator signed a new city ordinance and changed Mr. Scholes' position description that required he live on city property rent-free as a condition of his employment. Throughout the course of this investigation, Mr. Scholes and the city have asserted that he provides the city with security, saves the city money, and ensures the city follows federal security requirements. As noted in the investigation report, no one from the public was given the same opportunity to reside at on city property for free. In this case, 244.040 sub 2A provides an exception to the prohibited use of office by allowing public officials to accept the wages and other benefits provided as part of their official compensation package. However, this exception only applies to official compensation that has been specifically approved by a public body in a formal manner. In this instance, the city administrator approved a city ordinance and changed Mr. Scholes' job description requiring he reside at city property. The information provided does not appear to support the conclusion that the city administrator was personally authorized to make these changes. More importantly, even assuming that they did have this authority, the fact remains that from 2019 until December 29, 2023, Mr. Scholes did not pay for rent to live on city property, and this financial benefit was not included as part of his official compensation package. Therefore, it does not meet this exception. Next, Mr. Scholes had an actual conflict of interest and failed to disclose his actual conflict of interest in writing to his appointed authority. While the exact dates are unclear, it appears there was a verbal agreement between a former city administrator and Mr. Scholes that allowed him to live on city property sometime in 2019. However, Mr. Scholes left and later returned to live at the city property and provided security in his official capacity. In doing so, he was met with an actual conflict of interest as this resulted in a private financial benefit of avoiding paying for rent for both his RV and trailer. During this investigation, Mr. Scholes admitted to failure to comply with the conflict of interest notification requirements. Furthermore, he reported there was no conflict of interest because he was allowed by his appointed authority to live on city property. By failing to submit a written notification of the nature of his conflict of interest and failing to request his appointed authority dispose of the matter, Chuck Scholes violated the conflict of interest provisions in ORS 244.120 sub 1C. The investigation into the matter of Mr. Scholes raises the fundamental question of who is ultimately responsible for ensuring their actions comply with government ethics laws. As summarized in the Guide for Public Officials, the restrictions placed on public officials are different than those placed on private citizens because service in a public office is a public trust, and the provisions in ethics laws were enacted to safeguard that trust. Thus, each public official must make a personal judgment in deciding matters such as the use of office for financial gain and when to disclose a conflict of interest. There is a preponderance of evidence in this case to establish that Chuck Scholes engaged in a prohibited use of office and was met with an actual conflict of interest. I hereby move that the commission find there is sufficient evidence that Mr. Scholes violated government ethics laws and that the commission adopt the investigation report as its preliminary findings in order that this case be moved to a contested case proceeding or that a negotiated settlement be entered. Thank you.
Thank you, Investigator Pacheco. Commissioners, do any of you have any questions for Investigator Pacheco? Okay, seeing none. Mr. Schultz, good afternoon. My name is Sean Lindsay, and I'm the chair of the Oregon Government Ethics Commission. We appreciate you being with us today. Now is your opportunity to speak to us and give us your side of the story. We are running short on time, though, so we do ask that you be precise and brief and to the point, and we look forward to hearing from you. Thank you.
Yes, sir. Thank you for the opportunity to sit down and talk to you since last time I wasn't able to due to computer issues and phone issues. To keep it brief, which is out, while I have issues with the summary and it being biased in my opinion and not containing factual information as it goes through, I still stand by my original letter that I wasn't paying rent for for providing a night security at Legacy Valley Farms. And I was there in 2019 with the adjustment to the AWIA Act. It lists out general categories of how we have to protect our infrastructure from trespassing, domestic and foreign terrorism. So in a casual conversation, it was offered up by my boss to go, hey, why don't you just go back there till we build the infrastructure and take care of that. Since you're not paying rent where you're at, you won't pay rent here. There's no monetary benefit. Nobody saw that as an issue. It's taken a bit longer than expected to get the infrastructure done, but I look forward to going back to my location at Legacy Valley Farms. And one of the letters provided to you from that property owner states they want me back still. And I look forward to getting back there where I have full utilities and don't have the smell of poupons all the time. But to meet those regulatory requirements, there's only one individual listed at our critical facilities. And that's my name because as I'm sure many of you do in small towns, we wear so many hats. I'm also the operator. And it's my licensing and certification that keeps that running. While the city owns the property, I have to keep it out of trouble with our regulatory authorities. And right now, until the infrastructure gets completed, if somebody's not there, then we're getting fined and violated from the other side. So I don't think this is a very strong complaint.
Thank you.
And I'm available if you have any questions for me.
Thank you. Commissioners, does anybody have any questions for Mr. Schultz? All right, seeing none, what does this mean if we were to find a preliminary finding of one violation? What's the likely outcome on that?
So from my understanding, the prior investigator had offered a stipulated final order of $5,000 to Mr. Schultz in order to settle the matter based on the violations and his time that he's been living there. And he had declined the settlement. So that's why we moved forward to the investigation. So assuming that after this investigation, if the case moves forward, then he'll have the option that we'll go back to settlement, or he'll have the option to do the contested case hearing.
And what's the solution for going forward?
Going forward, if the commission were to make preliminary finding a violation, we would offer him the opportunity to negotiate a stipulated final order, or he could request a contested case hearing.
Well, I'm talking about where he's living right now.
If his city council if the council formally adopts a written policy saying or makes it part of his employment agreement that he can live there without paying rent, then it would become part of his official compensation package. It's that it must be formally adopted, it must be in writing, and from 2019 to 2023, some informal verbal agreement, it doesn't meet the criteria.
Right. And that formal agreement could also include a bonus or a reimbursement.
It could include a bonus or reimbursement. My understanding is that that may have been proposed to, I don't know if it was to provide him money to pay any penalties that the commission might impose. I would caution the city and Mr. Schultz on that because a bill was passed several years ago that specifically prohibits using public monies to pay any penalties imposed by the commission.
Okay. All right, commissioners, any comments on this? Yeah, I'll tell you where I'm at on this. I see a technical violation. It needs to be cleaned up. It needs to be done right. Candidly, I feel bad saying that this guy violated something when he had an oral agreement and he proceeded on an understanding from a public official. And that's a pretty hefty fine as well. So, but that's my only comment. Does anybody else have any comments? And I guess I would say if we were to proceed with a violation and finding that if we were to discuss a stipulated order, I would think I would desire to have a more lenient position than the last offer.
Mr. Chair, just a quick to support your point of view. I would agree with that if we were to move forward. Just at first blush, without having studied this to the extent that Mr. Pacheco has or his predecessor, that strikes me as fairly hefty in light of other activities, in light of this specific situation, which can be remedied fairly quickly if local government, forgive the phrase, gets its act together and ratifies a deal that's been struck. It strikes me that that itself in some way, shape, or form could characterize the agreement that could be reached as opposed to finding the need for a monetary fine, especially in the 5K range. That strikes me as high.
My understanding, and when Hillary had the penalty matrix and she had the case, I believe that had been the recommendation of Ron. And it was based on the matrix primarily on the length of time that this went on, which adds points in the matrix. And then the estimation of, if he were to have been required to pay rent all this time, what is the financial benefit he's received from not paying rent? But I think if the commission made findings and we were to propose a stipulated order, we could revisit how it appears in the matrix and reduce the amount.
Mr. Chair, if one further question, if the commission should, in order to achieve our objective, to use our chair's word, quote, leniency, unquote, would our motion have to embed or embody that, or could the understanding, the discussion we've had this afternoon, provide sufficient advice to staff to proceed if we were to proceed? Does that make sense?
Yes. The motion that you would be making, it would not change the motion. Your motion would be to make preliminary findings and offer either a contested case hearing or negotiate a STIP. At the time we negotiate a STIP, if that STIP deviates from the penalty matrix, when we bring it back to you, if the matrix says you should be paying 10 to 20% and we're saying, no, you don't have to pay anything or whatever, at that time, the commission would need to make a finding on the record to deviate from the matrix.
Okay.
That's fair, Mr. Chair.
That works for me. Any other comments from commissioners? All right, if you're prepared to make a motion.
Mr. Chair, for the record, armed with the last discussion of the last 5 minutes, I hereby move that the commission find there is sufficient evidence that Mr. Chuck Scholes make a preliminary finding, pardon me, just a minute, I'll get there, that responded, Chuck Scholes may have violated ORS 244.040 sub 1 and ORS 244.120 sub 2 and that the commission adopt the investigation report as its preliminary findings in order that this case be moved to a contested case proceeding or that a negotiated settlement be entered. I would add my own view that the latter would constitute our priority. Thank you.
Thank you. Commissioners, any comments on the motion before us? I agree with that. I think the message is clear. And Mr. Schultz, thank you for appearing with us today. With that said, we'll call for the vote, please.
Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley. Aye. Chair Lindsay,
Aye.
motion passed 7-0.
Thank you, Mr. Schultz, for being with us today. Our staff will be in touch and I think this will be resolved somewhat quickly. Thank you. All right, we're done with reports on investigation. Now we're on to let's see, correspondence, received responses, and miscellaneous items. And if I had my recommendation, I'd say we'd be very quick about this.
Yeah, the correspondence is simply provided for informational purposes. So I would ask that we move to items 81. There are actually two items 81, I apologize. The second item 81 and item 81A, which are two requests for extension of time for commission advisory opinions. Both of these requests for commission advisory opinions came in at the end of May. And we have a statutory 60 days to complete a commission advisory opinion, but your next meeting is not until August 2nd. So we need to ask for the extension. While the extension must be for an additional 60 days, our intent is to bring both opinions to you at the August meeting.
That is granted. Or do we need to have a vote? I hereby declare.
I think you have to have a vote.
Oh,
Mr.
okay.
Chair, I hereby move that we accept staff requests for extensions of time for 2 commission advisory opinions. Is that adequate?
We had to do one by
I
one.
think they have to each be separate.
I hereby move that we accept the staff recommendation for an extension of time for an advisory opinion related to Marie Tyball.
All right, seeing no comments, we'll call for the vote.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Oh, but
I'm sorry, where are we at here?
Commissioner
Oh,
Fiscum,
pardon.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley. Aye. Commissioner Burke,
Commissioner Burke?
Aye. Aye.
Chair Lindsay,
Aye.
motion passed 7-0.
81A.
Does the second one involve Mrs. Tyball as well?
it's William Kirby.
Mr. Chair, I hereby move that we accept the request from staff for an extension of time for a commission advisory opinion relating to Mr. William Kirby.
Seeing no comment, we'll call for the vote.
Commissioner Mason.
Aye.
Commissioner McCauley. Aye. Commissioner Burke,
Aye.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Chair Lindsay,
Aye.
passed 7-0.
Okay, thank you. Investigator Myers.
Item 82 is the meetings, the proposed meeting schedule for 2025. We need the commission to approve the schedule now because by the next meeting, the 6 months for an investigation would move into 2025. So the dates we proposed fit as closely as we could get with those investigation periods.
Okay.
Mr. Chair,
Can I wave my wand and approve it, or is it a vote?
He says they must vote.
Let's vote.
Mr. Chair, I hereby approve the Oregon Government Ethics Commission meeting schedule for 2025.
And we'll call for the vote.
Commissioner Newell,
Aye.
Commissioner Fiscum,
Aye.
Commissioner Payne,
Aye.
Commissioner Mason,
Aye.
Commissioner McCauley.
Aye.
Commissioner Burke,
Aye.
Chair Lindsay.
Aye.
Motion passed 7-0.
83.
Items 83 and 84 are the strategic plan and the DEI plan. These are presented solely for informational purposes. We as an agency are required, like all state agencies, to create such plans, but we are simply presenting them for information. The commission is not required to vote on or approve these plans.
Thank you. All right, agenda item 85.
Hello, my name is Chris Bruaker. I'm a trainer, part of the training team with Oregon Government Ethics Commission. And I'm going to be going over the trainers report. We've been pretty busy since the last meeting. We had 11 in-person trainings that reached over 20 city and county entities. All of our trainers were out and about. We had Lex, who was at Mount Vernon, and John Day. I traveled to Drain and Oak Ridge. Charlie was Brookings and Gold Beach. Stephanie traveled to Shaniko with Daniel, who got to have some fun out there with those people. And then Ruth has been putting in a lot of work because we are creating a new training for we have a new employees orientation. It's going to be a new board members orientation that's geared more towards specifically how those operate versus employees. And so she's been focused on that. Susan provided a brief training for how the public meetings law uniquely impacts the independent research and science team.
I forgot. Included it.
So she was she got that blessing, and then training team's been working really hard, providing technical support for the rules advisory committee meetings. And then we're also working on getting Garibaldi's schedule with their STIP training. We did have our Ethics Matters newsletter, volume 5, issue 2 came out, and that's been added into your packet. We got a lot of positive feedback from many different agencies about that, so we're pretty proud of that. We also had Ruth actually made it into the newspaper in Ashland for when she provided her training there. And that's been provided to you as well. I'm pretty proud of her. She did a great job there. And as far as moving forward, summer can kind of be light on trainings a little bit just because of vacations and things like that. But we are doing a ton of outreach right now, getting prepared for the fall so we can hit the ground running once everything comes back to normal. So.
Excellent. Thank you.
Yeah.
Appreciate it. All right, Executive Director Myers.
So to begin with, if Commissioner Hollister were here, we would be presenting her with a lovely plaque and appreciation for her years of service. Second, I do want to formally introduce to the commission our 2 new employees. We are fully staffed. I feel like I have been recruiting for the past 2 years. And so very grateful. Casey Fenstermaker, as you know, came to us from Pennsylvania. She is the new compliance and enforcement coordinator, and she has jumped in with both feet and absolutely hit the ground running. And then Josh Sullivan is our new investigator. He formerly was with the Yamhill County Sheriff's Department and also served as a crypto linguist. Yeah, with the Oregon Army National Guard, listening in on secret Korean messages or something. I don't know. So he's been here barely a week, a little over a week. So the budget numbers are in there. Becky is working with our analysts to get our agency request budget narratives done. The legislative session, I mentioned last time that we had submitted legislative concepts. In working with the governor's office and legislative council and DOJ, I chose to pull the one concept about the preliminary review phase because I still think it is worth considering, but I was a little unhappy with the language and sort of how rushed my analysis and consideration of it was. But then we did propose to substitute language that would create a new exception in 040 that would allow judges and lawyers who work for the government to teach at law schools without violating the prohibited use of office statute, because if you want judges to teach at law schools, but all judges are public officials, and the reason they're asked is because they're judges. So that Sean and Dan helped craft that language, and we were allowed to substitute. Rulemaking for public meetings law is continuing, still working on it. Cases, we are getting plenty. The OLCC cases, in case you might have noticed, there was a report in the newspaper, the criminal investigation ended. We did reactivate, they're no longer suspended. Those should be coming to you at the August meeting. That's my report. We're doing well.
Okay. Thank you very much for your tenure. All right, that brings us to a close to our meeting today. We thank everybody for coming, and we now are adjourned. Thank you. So quick point, I'm out August 2nd.
Oh,
You, is that an issue?
yeah, it is.
Gonna miss me?